is different from one another, my lords. However, in the instant case, we are looking at a chatbot that is specifically designated and designed to address the legal issues, my lord. As your lordships rightfully stated, so artificial intelligence software such as ChatGPT per se has all the information in the world, that is science, math, coding per se. But my lords, in the instant case, the chatbot is designated only to address the legal issues.
Will you be happy if we say it is an artificial person, not a person?
My lords, the counsels for the petitioners would be pleased if you could kindly adjudge that it is a person.
What is the advantage that you have when we say he is a person, it is a person?
Yeah.
Or what is the disadvantage when we say it is an artificial person?
Yes, my lords. My lords, if it is to be held as an artificial person, then it would not have the notion of a person being in law, my lords. So, if you could please grant me 5 more minutes, my lords, I have certain case laws and jurisprudential aspects, my lords, to cite before this bench. Much obliged.
Take jurisprudential aspects first.
Okay, sure, my lords. Much obliged. My lords, if you could please refer to 1.5 of our memorandum, which has been cited in page number 11 of our memo, my lords. The petitioner contends that human refers to a biological category, while person refers to an entity with a set of capabilities, and that legal persons are the sole bearer of rights and duties, my lords. The most common and intuitive definition of a legal person is a natural person or a human being, my lords. This is because human beings have the virtue. Page number 11, my lords.
Don't be so fast.
Sure, my lords. Much okay. Please, my lords. My lords, the most common and initiative definition of a legal person, as provided for in 1.7 of our memorandum, is that humans are called natural persons because they have the virtue of being born, my lords, not by legal decree. But this Honorable Apex Court, in various judgments from time to time, has reiterated the fact that by a legal decree, corporations and any inanimate objects such as ships, rivers, and animals also are deemed as legal persons through various judgments, my lords. Furthermore,
can we equate those persons defined equal to the artificial intelligence?
no, my lords, the counsels for the...
For example, you said ship.
Yes, my lords. Please, my lords.
Is it equivalent to your artificial intelligence or chatbot?
No, my lords, no, my lords. My lords,
How can you call it as a person?
yes, my lords.
That's a basic question.
Yes, my lords. My lords, in this particular aspect, even though we cannot have a direct comparison as to with a ship and that of an artificially intelligent software, if we refer to 1.12 of our memorandum, my lords, that is provided for in page number 13 of our memorandum, my lords, Salmon on jurisprudence. Please, my lords. Please, my lords.
Why you are making this submission?
My
Why
lords.
are you making this submission?
My lords.
Whether chatbot being artificial person, legal person, or natural person is going to make any difference for your case.
My lords, currently.
Do you want us to decide whether the chatbot is a person or not, or your anticipatory bail question?
My lords, we are in the Honorable Apex Court, my lord, before this Honorable Court, and my lords, though this case has a preliminary question of both fact and law, my lords, issues 1 and 2 are completely pertinent to substantial question of law, my lords, as your lordship pleases. So, my lords, if we could please look at issue 1, it states in general as to whether artificial intelligence is to be deemed as a legal person, my lords, which is why the counsels for the petitioners have felt the imminent necessity to argue upon this substantial question of law, my lords. My lords, as you rightfully asked, legal persons being the arbitrary creations of law may be of as many kinds as the law pleases. And Salmon, in his Natural Sources of Law, states that personality in the philosophical sense means the rational substratum of a human being. That is the virtue of being born, my lords. However, in legal knowledge, that is to be granted legal personality, it has to be a right and duty-bearing unit, my lords. So this has been held in case of Shiromani Gurudwara Prabandhak Committee versus Somnath Das, my lords, which is provided for in page number 10 of our memorandum, my lords. If you could please refer to 1.3 of our memorandum. In this particular case, a subsequent bench of this Honorable Apex Court laid down as to what the definition of a legal person is for the first time in the year 2000, my lords. And the Honorable Apex Court was of the opinion that, however, for a bigger thrust of socio-political scientific development, evolution of a fictional personality to be a juristic person became inevitable. This may be any entity, living, non-living, inanimate object or a thing. In other words, the entity acts as a natural person but only through a designated person, my lords. My lords, if this has to be taken into this instant case and artificial intelligence in general, my lord, artificial intelligence is a non-living, inanimate object that is capable of performing specific tasks that legal persons do, and it is a legal person per se that attributes a personality to law, my lords, thereby making it a go forward to be a legal person, my lords. And the same. Please, my lords.
Last sentence in Sharamni's case.
Please, my lords.
Read that once again. In other words.
In other words, the entity acts like a natural person, but only through a designated person who acts are processed within the ambit of law.
So, who is the person who is pushing the buttons?
Please, my lords. Please, my lords. My lords, that is the same question to be asked, my lords, and we respect that question, my lords, and we are of the opinion, my lords, that we do not have any problem per se. I am sorry to be using the word problem, but then we do not have any contention otherwise to say that there should not be a person behind it, my lords. My lords, if you had seen in US courts, my lords. Please, my lords. Please, my lords.
You want to take chatbot?
Sorry, my lords.
You are of some opinion, no? You are saying that we are of the opinion that who gave you this opinion?
My lords, in the instant case, we are strictly arguing upon the substantial question of law, my lords.
If you think that that AI is so powerful, can match a counsel who stands before the court, you bring it here.
My lords,
Present its case.
my lords, the council's contention is nowhere that AI has to replace judges or councils. My lords.
Who has had your services?
Natural person, isn't it?
Yes, my lords. My lords, the councils are of the opinion. The councils are nowhere saying no to the fact that there exists a creator behind this, beyond this AI, my lords. The councils for the petitioners are completely fine with the fact, but it's just that, my lords, in various other jurisdictions and jurisprudences per se, especially America and UK, my lords, there has been artificially intelligent softwares which are capable of inventions, my lord, and they have invented many such things, and my lords, patent has been granted under US law, holding that it is a juristic person, my lord, even though the creator is originally the natural person, my lord. My lord, the counsels for the petition would like to sum up this argument by citing 1.17 of our memorandum, my lord, which is given for in page number 14, my lords. My lords, if you could please refer page number 14 of our memorandum. 1.17 talks about M. Siddiq versus Mohan Suresh Das, which was the Ayodhya Ramabhoomi judgment rendered by the Honorable Apex Court, a subsequent bench of this Honorable Court, my lords, wherein the Honorable Apex Court concluded the rationale of granting the status of a legal personality to an idol, my lord, that is the Hindu idol. And the Honorable Apex Court was of the opinion that the first is to recognize the pious purpose of the testator as the legal entity capable of holding a legal right.
No, Mr. Counsel.
Please,
Idol is not cognitively competent.
sorry, my lords.
Idol sits quiet. It
Please,
will
ma'am.
not think.
Does it think?
No, my
It
lords.
will
Then
not
how can
think.
you compare the
No.
idol definition of the person with your artificial intelligence?
No, my lords, the counsels for the petitioners are not comparing as to whether an idol and artificial intelligence is to be placed on the same pedestal, my
What
lords.
is the ratio laid down in this case?
My lords, that's it, my lord. That the first is to recognize the pious purpose of the testator, and the second is the merging of the pious purpose itself and the idol which embodies the pious purpose to ensure the fulfillment of that purpose, my lords. That is,
How do you compare this with your present case?
yes, my lords.
Of the chatbot?
My lords, the counsels for the petitioners are nowhere comparing or telling that a Hindu idol is to be equated with it, but we are just of the opinion, my lords, that all of these are inanimate entities or objects which fall under the purview of legal person.
Yeah,
No
yeah,
problem
if you-
with a natural person and juristic person. There's absolutely no problem. We
Please,
have
ma'am.
said hundreds of times.
Please, my lords.
But according to us,
We are
we
on
are asking chatbot
Please, my lords.
can be treated as natural person or
Legal.
judicial person.
Yes, my lords. My lords,
This judgment will not help you.
my lords, no, my lords. This judgment was just to encompass as to what the Honorable Apex Court opinion was and the expansion of the term legal person, my lord. We are not telling this is in direct reiteration to our case. We are just of the opinion that these are some of the cases where some of the entities were held as legal person, and the main aspect was to that has to be fulfilled to confer legal personality is to be any object capable of performing human tasks and to have intelligence and to have legal rights and duties, my lords, which artificial intelligence in general satisfies, my lords.
If we follow this precedent,
My lords, please, my lord.
your charting has to stop charting. Okay, it has to keep quiet.
Please, my lords.
If that's acceptable to you,
No,
then
no.
don't press on CD.
Please, my lords. My lords, with your permission, the counsels for the petitioner would like to proceed to issue number 2, my lords. My lords, issue number 2 is stated in page number 20 of our memorial, my lords. 1 second.
What is the issue?
My lords, page number 15 of the memorandum, the counsel seeks apologies. Yes, my lords. My lords, second issue states whether report of jail or bail chatbot constitutes an opinion of expert admissible under the Indian Evidence Act 1872, my lords. My lords, the counsels for the petitioner seeks to argue this in affirmative and would like to state again that this sophisticatedly, meticulously crafted AI tool has the capability in it to be called as an expert opinion admissible, my lords, and the counsel would like to address this in a threefold manner, my lord. My lords, first is with regards to scope of artificial intelligence in Indian judiciary, my lords. My lords, if you could please refer page number 16 of our memorandum. 2.3 point, my lords. India ranks 13th out of 200 countries in developing artificial intelligence and have already integrated AI in agriculture, health and judiciary, my lords.
Mr. Counsel, you are arguing for issue 2 or 3.
2, my lords.
Have clarity. What is your issue 3?
My lords, issue 3 states whether reliance on the report of chatbot amounts to abdication of a judge's judicial
Now
function.
you are speaking about artificial intelligence in judiciary.
Yes, my lords. I'm talking about whether artificial intelligence has the capability in it to be an expert opinion under Indian Evidence
I'm going to
Act.
that.
Yes, my
Don't
lords.
speak up judiciary now.
Yes, my lords. My lords, the counsels for the petitioners would like to quickly take you to 2.4 of our memorandum, my lords, wherein my lords.
Mr. Counsel, you are advised to make your submissions.
Please, ma'am.
Page numbers and spoil your time.
Please,
What
ma'am.
is your case? Present case, not these numbers.
Please, my lords.
Okay?
Please, my
It
lords.
is there with us. We will check.
Much obliged. Much obliged, my lords. My lords, 2.4 states the adoption of AI, my lords, through a Mancorp Innovations Lab, that is the MCIL, to address the challenging outstanding cases. My lords, as your lordships are already well aware that early in 2021, my lords, the Supreme Court portal for assistance in court efficiency, that is the SUPACE, was established by the then Chief Justice Shri Arvind Bobde, my lords, and this was specifically made, which included e-office, user and task administration, automated fact extraction, chatbot, etc., my lord. This was to help assist the judges in speedy disposal for the apex court, my lords. Furthermore,
Does
please,
this apply
please,
to giving judicial opinion?
my lords,
It does not.
my lords,
The administration is different. It is set pattern.
please, my
Whenever
lords,
set patterns are there, we said that all right, you can use artificial intelligence.
please, my lords,
Appointment of staff.
please, my lords,
Okay, how many staffs to be appointed,
Please, my lords.
depending upon various considerations.
please, my lords,
But can it be equivalent to
please, my lords.
giving opinion, legal opinion?
No, my lords, the council.
This CCPS you have looked into, what is that?
Please, my lords. Please, my lords. My lords, if you could please look further, my lords. 2.6. The MCIL created a system.
You want us to have an Alexa here in the court?
No, my lords. My lords, the counsels for the petitioners would like to humbly plead that later on, for the speedy disposal to help the Patna High Court, my lords, the same MCIL created a chatbot which, based on algorithm, assigned the cases and the kind of cases that were to be heard by the bench, my lords.
That's all.
Yes, my lords.
That is based
That's
on
all
what
it
is
is.
fact.
That's all
Please,
we
my
are
lord,
saying
please.
immediately.
Please, my
It
lord.
is made for administrative purpose. Now it will sort out.
Please,
It will
ma'am.
not do cases, how many are there, separate them. That's all is the work. It has no power to give its opinion.
My
Now
lord.
this case does not fit under 302, it cannot say.
Please, my lords.
Then how can it be a juristic person?
Please, my lords. My lords, the only contention of the counsels for the petitioners today before this honorable bench of the Apex Court is that AI in nowhere can replace the judges or is even close to equating the judges, my lords. My lords, if
Then
it
why you are insisting upon us to rely upon that report?
my lords,
And you are saying that High Court has failed to look into that. Why you are insisting?
my lords, the counsels for the petitioners are clear on the contention that it is completely upon the discretion of the Honorable Apex Court and Honorable High Court judges whether or not to consider the opinion, my lords, and the counsels for the petitioners in nowhere are mandating you to use as such, my lords, and it's only
Mr.
please,
Counsel,
please, my
what
lords,
is expert evidence
please, my lords, my lords, expert evidence is
as per the statute?
yes, my lords. Expert evidence is given for under section 45 of the Indian Evidence Act, my lords, and talks that whenever there are certain fields of law, that is handwriting expert or art or foreign law or expert evidence per se, the court can make use of the expert opinion base it on the merits of the case to come to a logical conclusion, my lords. My lords,
Scientific data.
yes, my lords.
It's only scientific data
Please, my lords.
which can be given, opinion given by. Like,
Please.
Your arms, etc.
Please.
signature, blood group.
Please, my lords.
But that doesn't become equivalent to
Please, my lords.
giving an opinion on law point.
Please, my
This
lords.
is all we are asking.
Please, my lords. My lords, the counsels for the respondents would like to kindly take you to 2.14 of our memorandum provided for in page number 18, my lords, wherein we would like to cite the case of Jaswinder Singh versus State of Punjab, my lords, wherein this was a case under 302 and 306 IPC, and my lords, the Punjab and Haryana High Court rejected the bail petition, my lord. However, the learned single judge, that is Mr. Honorable Justice Anup Chitkara, sought the input of Chat GPT, my lords, which is a GPT, which is AI, my lords, for the jurisprudence on bail, my lords. However, the Honorable learned single judge made it clear, my lords. He was clear in his fact that AI can be used only for assistance on the point of law, not on the merits of case and not to give judgment, my lords. So the counsels for the petitioners are very well aware of the fact and are nowhere imposing that, my
It
lords.
is a very clear proof of the fact that the Honorable Judge said this should be shown its place. AI should be shown its place. It cannot go beyond that line.
Please, my lords.
Ultimately, judge is there, who will decide.
Please, my lords. Please, my lords. My lords, if you could please refer.
But you are submitting, no?
Yes, my lords. Exactly, my lords. We are nowhere of the my lords. The council would like to make a small submission that if the global pandemic.
What the judge, in fact, single judge has said is,
Please, my lords.
this is not an expert.
Please, my lords.
Okay, I take its assistance. He is my assistant.
Please, my lords. Please, my lords.
Expert leads,
Please, my lords.
assistant assists.
Please, my
I
lords.
take the lead.
Please, my lords. Furthermore, my lords, in the cases Ramesh Chandra Agarwal versus Regency Hospital Limited, Titli versus Alfred Robert Johns, the Honorable Apex Court was of the opinion regarding subsequent bench of this Honorable Court, my lords, with regards to section 45 of the Indian Evidence Act, was of the opinion that the work of an expert is to put before the court all the material and reasons which make it to reach a logical conclusion. The SC also reiterated that the role of expert is that of an advisory character and it is solely for the basis of assisting the judges, my lords. So the counsels for the petitioners humbly pray that we nowhere intend to replace the judges, my lords. My lords, even though if the algorithm evolves on its own, considering the societal and cultural aspects and considering the ability to express discretion in certain cases and contextual understanding, contextual decision making based on the fact, AI can nowhere come close to the honorable judges, my lords, because a human mind can never be replaced, my lords. And the exact same thing was held by the to-be Chief Justice of India, Honorable Justice Mr. Sanjay Kishan Kaul, my lords, yesterday, my lords. Yesterday, a Law Asia 36 South Asian Conference took place, my lords, in Bangalore, wherein Honorable please, my lords.
When one of us are expecting to be next Chief Justice,
Please, my lords.
how you can designate somebody?
You can't say that. We don't know whether you will be there or not.
Please, my lords. The council seeks.
Jumping around.
Sorry, my lords. The council seeks apologies for the same, my lords. My lords,
This is so and
please, my lords. My lords, the opinion of my lords, if you could please refer to the annexures provided by the honourable councils for to the honourable bench by the councils for petitioners. My lords, in the conference that took place yesterday, the Honourable Mr. Justice Sanjay Kishan Kaur was of the opinion that AI can be harnessed and used for legal research and assistance for the cause of justice, but it can nowhere come near to replacing a human, my lords.
The question comes,
Please, my lords.
to you.
Please, my
It's
lords.
an opinion.
Please, my lords.
Fine?
Please, my lords.
Agree?
Please, my lords.
If it is an opinion,
Please, my lords.
it can be yes or no.
Yes, my lords.
Then what is wrong with the High Court saying that we don't rely?
My lords, the High Court is certainly.
And why you are insisting that it should be relied upon?
My lords, that is because the councils for the petition.
Ultimately, it is an opinion.
Please, my lords. Please,
We
my lords.
may accept, we may not accept.
Please, my lords.
Then why you are insisting that it should be accepted at all?
Please, my lords. My lords, the councils for the petitioners have approached this Honourable Apex Court through this SLP because there existed an imminent necessity to bring in AI, my lords. Because various other. Please, my lords. Please.
SSP is admitted to give you an opportunity to prove that
Please, my lords.
AI is creditworthy,
Please, my lords. Please, my lords.
reliable.
Please, my
And
lords.
except establishing reliability of AI, you are speaking of so many other things.
No, my lords, the councils for the petitioners are of the opinion that with the changing landscape of
AI
Indian.
has an opinion, as a council, you also have an opinion. We are expecting some submissions.
Please, my lords. Please, my lords.
Some submissions.
My lords,
Based
the-
on law.
You are arguing
please, my lords.
what opinion
Please, my lords.
can constitute expert opinion.
Please, my lords.
It can be reliable under the Evidence Act.
Please, my lords.
You refer to section 45.
Please, my lords.
See, when the court seeks expert opinion,
Please, my lords.
it is subject to cross-examination
Please, my lords.
to find out whether the expert opinion is reliable or not.
Please, my
In a
lords.
given case, can we do that? Who do we call upon?
Yes, my lords. My lords, again, for this particular question to be answered, my lords, the councils for the petitioners are of the opinion that, my lords, we are strictly before this honourable apex court and we would like to argue upon the substantial question of law, my lords.
Council now
It
onwards,
is a substantial question.
Yes, my lords.
don't express opinions. Councils are of the opinion. We have not come here for your consultation.
Please, my lords.
You have come here to make your submission.
Please, my lords. My lords, the petitioners humbly submit that with the changing of legal landscape in Indian judiciary, there exists a need for AI to maybe come to assist the judges, my lords, with the overburdening of the cases, my lords, and there are no such precedents set by the Honourable Apex Court, my lords.
Your issue is whether it can be treated as expert opinion under the Evidence Act.
Yes, my lords.
Section 45.
My lord, yes, my lords.
That if we treat it as expert opinion,
Exactly.
if the other counsel wants to cross-examine and find out to prove that this is not correct,
Please, my lords.
whom the court should call upon.
Please, my lords, my lords, the counsels for the petitioners would like to humbly submit that through this case, my lords, we want you to set a precedent once and for all for AI, my lords, as in the current Evidence Act, my lords.
Sir, you have not understood the question.
Please,
See, if it is an expert's opinion,
please, my lords.
we accept for a moment.
Please, my lords.
Now, how it has to be proved?
Please, my lords. My lords,
It is the opinion in
please,
writing.
please.
How it is to be proved?
My lords, it has to be authenticated and signed duly by judges and
No.
Expert.
Expert must be examined to prove what opinion he has given,
Please.
so that we can understand his mentality
please, my lords.
and how the process he has undergone.
Please, my lords.
Then other side has got opportunity to cross
Cross-examine. Please, my lords.
Now, in this case, my brother is asking
Please, my lords.
whether we can cross-examine your so-called AI.
Yes, my lord. Please, my lords. My lords, currently there is no scope for cross-examination, my lords. But then, in the years to come, my lords, with the changing of legal landscape, AI will be on the forefront, my lords. So, through this case, we want you to set the precedent, my
When
lords.
it comes to that, we will consider the case.
My lords, so through this case, we would like you to set a powerful precedent, my lord, once and for all with regards to AI, my lords.
No, it is like this.
Please, my lords.
AI is a very vicious thing.
Please, my lords.
In the recent war, with the what is this war going on, Gaza,
Yes, please, my lords.
it created so much of information and
Please, ma'am.
proved it out that the intelligence of Israel was misled
Please, my lords.
because there was so much of communication, etc., etc.
Please, my lords.
Ultimately, it went
Please.
to targeting of wrong things.
Please, my lords.
Okay, what the chief is asking is,
Please, my lords.
your AI works on the basis of some formula.
Please, my
What
lords.
is the reliability? What is the test? What is the credibility of your AI?
Please, my lords.
That's what you are to establish.
Please, my lords.
Point 2.
Please, my lords.
If your AI has credibility, for what reason it has credibility, you have to prove that.
Please, my lords.
And maybe if it is credit worthy, that credit will be given.
Please, my lords.
Otherwise,
Most certainly, my lords. My lords, currently, to even ensure or to even put forth.
if
Please,
we
my-
ask a question to your AI,
Please,
whether
ma'am.
it is nice to get married or not,
Please,
it will give some opinion.
please, my lords.
Then somebody will come to me, sir, I got married, now this chatbot says getting married is not good, please grant me divorce. But it is ground is chatbot.
Please, my lords.
Okay.
My lords, this connotation is generally with regards to general AI, my lords. That is open AI or any default AI as such, my lords. And currently, there is no law or there is no law to enforce AI to be credible, my lords. My lords, so we completely understand the concern, my lords. And through this case, if at all amendment can be made, or my lords, the councils for the petitioners humbly pray that you could direct to bring in a legislation, my lords, with regards to AI, and any AI that is to be made is to undergo strict scrutiny, and only after passing all the credibility factors and only after passing all the tests as laid down by this honorable court may be it granted the status of an expert or even coming close to an expert, my lords. And for any actions of the AI, the creator of the AI and the AI per se is to be held for its legal sanctions, my lords. The councils for the petitioners are okay with that, my lords. But the fact remains that in the years to come, my lords, the fact remains that in the years to come, AI is skyrocketing, my lords, and various other jurisdictions have approached it and have considered it as well. So, my lords, this councils for the petitioners humbly pray that such amendment be brought, at least to test AI, my lords, and only based on the discretions be considered, and the AI is ready to go through all the scrutiny, my lords, and some AIs, my lords, when particularly designed, that is all the algorithms in place, and 3.5 will answer strictly on the basis of subject matter, my lords. As in, if a math AI is created per se, my lords, any other question will not be entertained by it at all, and only questions relating to math will be entertained, and the same thing could be done with legal judiciary, going through strict scrutiny through this honorable precedent, my lord. So the councils for the petitioners humbly pray that through this case, a powerful precedent may be set for the AI for the years to come, my lords, because currently in the context of Indian judiciary, there are no much cases, my lords, per se, with regards to AI, my lords. My lords, the councils would like to conclude by stating that even though AI is not capable to come close to an expert or to replicate the judge, my lord, a chance may be given, my lord, by setting a powerful precedent in this case, and that is what the councils for the petitioner humbly prays for, my lord.
What chance to be given?
My lord, for the AI, my lord, the councils for the petitioners are ready to go through any kind of scrutiny to test all the factors required for the AI to be credible and for the source of the AI to be credible, my lord. Indeed, there exists a fear or a ambiguity per se as to what is the credit or what is the source of this AI. Where is it answering from? So, if at all, if that question is to be answered, my lord, the AI is to be created in such a way that it makes sure that all the factors are considered, my lord, and the council rests.
But tomorrow you may ask the judges should not be there, only AI should be sufficient.
No, my lords,
Given facts and circumstances of the case, the AI will decide whether to acquit or convict or whether give to partition or not. That's all.
No, my lords, as your lordships rightfully stated, my lord, AI in no sense can come close to replacing a judge, my lords, because
How can it come close to an expert evidence? That's all is the question we are asking.
my lords, we are not telling the expert opinion to be considered, my lord. It is completely upon your lordship's discretion, my lord, whether to consider it or not. And just like some precedents such as Jaswinder Singh versus State of Punjab, the honorable single judge.
So in this case, you do not want any remedy.
No,
You are just requesting for future things.
no, my lord, through.
When AI comes to that quality, then when
My
you
lords,
say-
the counsels for the petitioners humbly pray for doctrine of prospective overruling, my lords, that through this case, for the future cases, you give some remedy, sir.
Overrule what?
That AI be given a chance to prove its credibility, my lords, as a legal person, my
It's
lords.
not the issue, the
This
issue at
is the
hand.
problem.
Please, my lords.
Natural person can go so much wrong. How we can rely upon AI?
Please, my lords.
Council speaks of prospective overruling without any relevance.
No, my lords, the council just prayed that before this honorable bench, my lords. My lords, due to the time constraint, the council too will proceed with issues 3 and
Whether
4.
the court can give a direction to parliament and what has happened to all those directions that are given?
No, my lords.
Lawmaking power is with the legislature, we don't
Please.
have power.
Please, my lords. My lords.
Can we declare, direct the government to frame a law?
Please, my lords, through this particular judgment per se, a directive can be issued, my lords, because we are approaching under S.N.V.L under Article 136, my lords, and Article 142 gives this honorable bench all the necessary powers and ample powers to do complete justice
Not
in
to
this
make
case,
law.
my lords.
It doesn't give power to.
Please, my lords. Please, my lords. Only,
Lawmaking power is always with the legislation.
please, my lords. The contention is strictly not towards making law, my lords.
If we hold that the chatbot opinion constitute expert opinion under the Evidence Act.
Please, my lord.
If we were to hold that,
Please, my lord.
it will amount to violation of accused's right to cross-examine.
Please, my lords.
It's one of the principles of natural justice.
Rightfully, my lords.
Then how can we hold that this opinion?
Please, my lords. My lords, the council would like to conclude this by stating that, my lords, even in the judgment passed by K.M. Josephs and Honorable Justice Mr. K.M. Joseph and that judge bench with regards to Article 324 and Election Commissioner, there existed a void, my lord. There existed a vacuum with regards to Article 324. Similarly, my lords, in this particular case as well, there exists a vacuum, my lord. That is, these laws were made back in the 70s, and now with the evolving landscape of legal theory and a AI committee being especially set up in the Honorable Apex Court, there exists a particular vacuum with regards to these provisions, my lords. And until the vacuum is covered per se by the legislature, we honorably beseech this court to make necessary things, my lords. My lords, my counsel would proceed with issue 3 and 4, my lords. Kindly.
Do you have a counsel?
No. Counsel for the petitioner, my lords. Kindly grant a petition. Please, my lords.
Co-counsel. Is your co-counsel.
My Lordship's counsel takes
Yes.
Greetings to the bench. This is co-counsel, team number 14. Your Lordships, the council seeks permission to move on to issue number 3 and 4. Your Lordships, issue number 3, which states whether the reliance on the report of chatbot by a judge amounts to application of his judicial functions or amounts to acting contrary to the constitutional mandates of the judge. Your Lordships, the counsel for the petitioner would like to humbly submit that if there is any kind of reliance that is placed on the report by a judge, it shall not amount to application, nor shall it amount to any kind of constitutional contravention. Your Lordships, the above submission is not only backed by facts, but also with the precedent set by the Honorable Apex Court. Like your Lordships are well aware about the burden that is placed on the Indian judiciary. Just to give a factual insight towards this, your Lordships, if you could please refer page number 8 of the compendium. There is a report which is given by
The latter part that you were mentioning, latter part of your first statement.
Your Lordships, the council stated that it is not only backed by facts, but also backed by precedents that have been set by the Honorable Apex Court and that of the Honorable High Court, Your Lordship. Your Lordships, there has been a report which has been given by the Law Ministry, which has stated there are only 17 to 21 judges per million people in this nation, Your Lordship.
Yeah, proceed.
Yes, Your Lordship. Your Lordship, this very statistical data gives us the insight towards the amount of burden that is laid on the Indian judiciary, Your Lordship. The counsel for the petitioner.
Mr. Counsel,
Yes, Lordship.
you are not the Attorney General of India.
Yes, Lordship.
You are a counsel for a party. You do not know whether party has kept you in good humor by paying all the fees that you demanded or not. Okay.
Don't bother about rocket explosion, burden on judiciary, chief justice is there, the system is there, they will bother about it. You have to bother about your case.
Your Lordships, the counsel for the petitioners would like to state, as my responsibility as the officer of court, it not only becomes my responsibility but
You are
duty.
running into problems, you are not an officer of the court.
Yes, Your Lordship.
We decide who is an officer of the court.
Yes, Your Lordship.
Who gave you this title officer of the court? Where from you became the officer of the court?
The counsel seeks apology, Your Lordship.
Not apology, you have to, once you have said that you are an officer of the court, you have to tell us from where you became the officer of the court.
Your Lordship, the general understanding is that once a person enrolls in the bar.
Proceed.
Yes, Your Lordship. Your Lordship, when we look at the implementation of AI and that of judiciary at a global aspect, there has been great development, Your Lordships. For example, if we take the example of China has been a trailblazer with this aspect, Your Lordship. In China, there has emerged and it emerged as a
Why
trial.
are you going around? We know what is all this, your co-counsel has already argued.
Yes.
Now come to the issue, what is the issue?
Your Lordship, the issue revolves around if there is reliance placed on the report, does it amount to abdication? Your Lordship.
You concentrate on that, let us see.
Yes, Your Lordship. Your Lordship, it is the second principle of law. For judicial abdication to take place, the entire adjudicating process has to be placed in the hands which has no power. Your Lordship, that is not the case here. Your Lordship, the contention of the petitioner is that the AI, in this particular case, is only assisting the Honorable Judges, Your Lordship. So, when we look at the factual matrix and the principles that have been laid with the Honorable Apex Court itself, it is clear that there is no kind of application that would even come into picture if in case there is any kind of reliance that is placed on the report, Your Lordship. Your Lordship, if you could please refer 3.6 of the memo. Your Lordship, the case of Jaswendra Singh was the state of Punjab, wherein the Honorable Justice Anup Chilkara sought the guidance of an AI system called ChatGPT to gain a wider perspective on the aspect of granting bail. Your Lordships, when we apply the findings of this case, there is one clear outcome, Your Lordships. The entire employment of AI does not in any way constitute to making sure that the judiciary or the honorable judges are replaced by the AI, Your Lordship. The AI shall only act as a tool, a supplementary tool to ensure that there is more effective time management and redressal of cases, Your Lordship. Your Lordship, also in the case of Christian Louboutin versus Shu Boti, which is mentioned in 3.8 of the memo, the Honorable Court held accuracy and reliability of AI generated data is still in the grey area. Your Lordships, the counsel for the petitioners are in complete consensus with the above said judgment. However, Your Lordships, the counsel for the petitioners would like to make certain clarifications with the term grey area, Your Lordships. Your Lordships, as technology advances, the legal landscape evolves, and the nuanced issues surrounding AI in the adjudicatory process demand a definitive adjudication from the highest judicial authority, Your Lordship. Your Lordships, this bench possesses the wisdom and also the authority to make such changes, Your Lordships. Like Your Lordships have already rightfully stated, only when there is a platform set, there can be scope of development, Your Lordships. With respect to the Indian judiciary and the global aspect of AI and judiciary, there is no solid platform that has been set. Only with this presidential case, which can be set by the honorable bench, only then there can be a scope of development, Your Lordship. Your Lordship, the counsel for our petitioners would like to conclude with argument.
Mr. Counsel,
Yes, Your Lordship.
by setting precedents,
Yes, Your Lordship.
growth of law will be halted.
If Your Lordship may
Because
please.
if we say something that will be binding on all the courts under 141, the progress of law will come to a halt. Powerful precedent should not be set. Following precedent is like tail wagging the dog. Dog will die. Right?
Yes, Your Lordship.
That's why we should speak of law and interpretation of the, not precedent.
Yes, Your Lordship. So, if Your Lordship may please allow, Your Lordship, the particular issue at hand is such that there is no legislative aspect that can be put to picture to address the issues, Your Lordship.
Is this a legal problem
Yes, Your Lordship.
or a technology problem? What
Your
is that you want?
Your Lordships, the problem is based on two simple aspects, Your Lordships. One thing is that the entire issue.
As judges refer to various books, opinions, etc., and arrive at a decision.
Yes, Your Lordship.
There is some AI thing that has come into picture.
Yes, Your
That will
Lordship.
be taken note of by the court and court will decide.
Your Lordship, the current scenario of the judiciary with respect to OA is such that there is no view taken as to even form an opinion for the councils and the honorable citizens of this nation, Your Lordships. Only when there is a certain view that is even taken, only then there can be adjudications, there can be progress with respect to the issue. Your Lordships, the Council for Petitions would like to conclude with issue number 3 by stating the only thing constant is change. Your Lordships, moving on to issue number 4. Issue number 4 states whether the High Court erred in declining to grant bail to Harsh Kulkarni. Your Lordships, the Council for Petitions.
That is constantly change is what I got in my WhatsApp today morning. That is not a submission in the Honorable Supreme Court.
Apologies, Lordship.
And that is a straightforward. Somebody forwarded it without reading. A straightforward person.
Your Lordship, it was.
Making straightforward arguments.
Sorry, Lordship, it was mentioned by Adam Smith, who was a great economist with respect to this particular.
Speak of law.
Yes, Your Lordship. Your Lordship, moving on to issue number 4, whether the High Court erred in declining to grant bail to Harsh Kulkarni. Your Lordships, the Council for Petitions humbly submit that the Honorable High Court erred in declining the bail to Mr. Harsh Kulkarni. The above submissions are also backed by the very factual matrix of the case, along with the precedent set by the Honorable High Court. Your Lordships, if you could please refer 4.2 of the memo. In the case of Phaneendra versus Regency Hospital versus the state of HP versus Jailal, it has articulated the attributes of an expert, wherein the Honorable Ethics Court stated, an expert is anyone who has made a special study or acquired a special experience or a special skills and knowledge regarding the subject. In Lordships, when we apply the findings of the present case at hand, it becomes clear that the said chatbot stands as a testament to the embodiment of an expert in the realm of law. Your Lordships, its foundation is rooted in an extensive database of legislations and legal precedents, thus endowing it with a unique and specialized knowledge, Your Lordships. Your Lordships, if you could please refer 4.3 of the memo, the Honorable Apex Court in the case of Prashant Kumar Sarkar versus Ashish Chatterjee.
You are answer this 4-number issue you are arguing.
Yes, Your Lordship.
Does it connect anywhere related to your artificial intelligence now?
Yes, Your Lordship.
That's over now.
If Your
The
Lordship.
question is over.
Yes, Your
Whether
Lordship.
we accept it or not, that is different.
Yes, Your Lordship.
Now question is whether the tribe, when High Court was in error in granting, rejecting your bail.
Yes, Your Lordship.
Argue on that.
Yes, Your Lordship.
Artificial intelligence, forget it.
Yes, Your Lordship. Your
Now,
Lordship.
first question you answer.
Yes, sir.
Is it your fundamental right
With respect to Your
to
Lordship.
get a bail, anticipatory bail?
Your Lordship, the general understanding is that bail is an exception and jail is the rule.
Is it a fundamental right?
No, Your Lordship.
Why not? Article 21?
Your Lordship, Article 21 has.
Why not?
Yes. Article 21, it also has reasonable restrictions which can be placed according to the procedure established by law. And in case any person commits an offence and he is put.
If I am wrongly confined,
Yes, Your Lordship.
am I not entitled as my fundamental right? My liberty has been restricted unnecessarily, illegally. So give me a bail. That's all.
He is accused, he is not a convict.
That's all.
Yes, Your Lordship. Your Lordship, like rightfully stated by the Honorable Bench, even in the present case, he is just an accused, he is not a convict. Your Lordship, hence it is on based on this principle that the counsel for petitioners are asking for an anticipatory bail, Your Lordship. Your Lordship, in the case of Prashant Kumar Sarkar versus Ashish Chatterjee.
Concentrate on facts of the case.
Yes, Your Lordship.
They argue
Yes.
that whether High Court was justified.
Yes, Your
Now
Lordship.
forget about intelligence.
Yes, Your Lordship. Yeah, this is with respect to the
Now
anticipatory.
become a simple man. No, not intelligent.
Yes, Your Lordship.
Okay.
Yes, Your
Artificial
Lordship.
intelligence. You are in custody, whether you want to come out. Natural intelligence.
Yes, Your Lordship. Your Lordship, these two particular cases, which was dealt by the Honorable Apex Court itself, one being that of Prashant Kumar Sarkar versus Ashish Chatterjee, and the other being Gurbakh Singh Sipa versus State of Punjab. Your Lordship, with respect to these two precedent-setting cases, the Honorable Apex Court dealt with principles that have to be crucially examined with respect to assessing a bail application, Your Lordship. In this particular cases, Your Lordship, the Honorable Apex Court stated certain principles, wherein the first one was with respect to the existence of a prima facie case, and the second one was the antecedents of the applicant, including the fact as to whether the accused has previously undergone imprisonment on conviction by a court And the third one, Your Lordship, the possibility of applicant to run free, Your Lordship. Your Lordship, when we look at the principles that have been set by the Honorable Apex Court itself, the first principle which states existence of a prima facie case. Your Lordship, the counsel for the petitioners would like to back the submission made towards this Honorable bench that there is no existence of prima facie case with the help of the case of State of Gujarat versus Javandri Amultaji slogan. Your Lordship, in this particular case, the Honorable High Court stated if in case there is any contradiction to the medical report and that of the testimony of the victim, then it does not constitute a prima facie case. Your Lordship, when we look at the factual matrix of this case, in the medical report given by the very governmental authority states that there were no injury marks. And moreover, Your Lordship, the two main other aspects which have to be, yes, Your Lordship.
What provision you seek anticipated?
482. 438, Your Lordship.
438.
Yes, Your Lordship.
What are the parameters for granting anticipated bail under 438? That's all.
Yes, Your Lordship. Your Lordship, the
Answer is there in 438 itself.
yes, Your Lordship. The two main criteria that have been mentioned under the particular four main criteria which have been mentioned are such that if there is a possibility of the accused fleeing away, or if there is a possibility.
First one is the gravity of the offense.
Yes, gravity of the offense. If there the gravity of the offense, punishment, the chance of the accused fleeing, and the chance of the accused influencing the prosecution witness.
First one is criminal antecedents. Only these four things are looked into while granting anticipated bail.
Yes, Your Lordship.
And now connect these four things to the present practice.
That's all.
Yes, Your Lordship. With respect to the second factor, which states the antecedents of the applicant, including the fact as to whether the accused has previously undergone imprisonment. Not just when you apply this particular provision to the case at hand, it becomes clear that the accused here, Mr. Harsh Kulkarni, has nowhere committed an offence or also been convicted of an offence, Your Lordship.
First one.
The gravity of the offence.
Gravity of the offense.
You argue on that.
Yes, Your Lordship. Yes, Your Lordship. The counsel for the petitioners humbly submit that the offence that is under 376 of the IPC, it does amount to a heinous crime. But Your Lordship, another important submission before this honourable bench is that these are accusations, Your Lordship, and is not a convict. And Your Lordship, moving on to
Question of conviction does not arise here. See, all that you need to argue is that, considering that third para of the problem, right? Go to that and tell that what constitutes that offence of rape or sexual offence.
yes, Your Lordship, the evidence that has been placed by the prosecution before the Honourable High Court were that of the emails that was exchanged between the said parties, wherein the factual matrix of the case has clearly stated that the emails only contained emotions. Your Lordship, however, the term emotions can be interpreted in wide sense when we look at the very factual matrix of the case. The precedent set by the Honourable Apex Court and that of Mr. Harsh Kulkarni and the societal values which have been followed as a lawyer, it becomes clear that Mr. Harsh Kulkarni, who is the accused here, has nowhere committed said offence, Your Lordship. Your Lordship, the counsel for the petitioners.
Where else he can commit that offence? No, welcome.
Your Lordship, the counsel for petitioners would like to start with the prayer, Your Lordship. Wherefore, in the light of the facts presented, issues raised.
Only argued on gravity of the offence. Other three you did not touch.
No, time over. That's why he you would have had little more time, little more persuasive.
Your Lordship, the counsel for the petitioner shall move on with the prayer.
Yes.
Wherefore, in the light of the facts presented, issues raised, arguments advanced, and authorities cited, the counsel on behalf of the petitioner humbly prays before this honourable court may graciously be pleased to adjust and declare that artificial intelligence is a person in law capable of giving opinion. Report on bail or jail by chatbot constitutes an opinion of expert admissible under the provisions of Evidence Act 1872. Reliance on the report of the chatbot by a judge does not amount to abdication of judicial functions or does not amount to acting contrary to the constitutional mandate of the judge. The Honourable High Court erred in declining to grant bail to the petitioner, to set aside the order passed by the Honourable High Court and Sessions Court, and to grant anticipatory bail to the petitioner, Mr. Harsh Kulkarni. and or cause any order, direction, or relief that it may deem fit in favor of the petitioner in the larger interest of justice, equity, fairness, and good conscience. For this act of kindness of your Lordship, the petitioner shall duty mourn forever pray. Your Lordship, it was an honor arguing before this honorable bench.
Thank you, my lord. It was an honor arguing. What do you want? That's not. Not sorry, it was. Camera.
The council seeks permission to approach the police. Much obliged. The council belongs to Team 6. Warm greetings to the bench. This is council number 1 appearing on behalf of the respondent.
Madam Counsel, you are not supposed to offer greetings, compliments to the court.
Apologies.
Be totally professional.
Indeed, ma'am.
Please.
Indeed, Your Honor.
Proceed.
This is council number 1 appearing on behalf of the respondent in the case of Harsh Kulkarni versus State of Karnataka. The council seeks permission to state the jurisdiction. Much obliged, Your Honor. The respondent has approached this respectable court of India under Article 136 Clause 1 of the Constitution of India. The respondent maintains that the verdict passed by this Honorable Court of Karnataka High Court of Karnataka is just and fair, and therefore the respectable Supreme Court of India need not entertain this jurisdiction in the special leave petition. If Your Honors are clear with the jurisdiction, the council seeks permission to state the facts.
Not necessarily both the issues.
Go with the issue.
Much obliged, Your Honor. Moving on to the issue, there are 4 primary issues. The first issue is whether artificial intelligence is a person in law capable of giving opinion. The second.
Chief wants to hear brief facts of the case.
Brief
from
facts
your
you
side.
can say from your complainant side.
Your Honor, if you may permit me, I would like to say the facts, like the important points. Like
Yes, important highlights of your complaint.
Your Honor, Smita Murthy and Harsh Kulkarni met at an IP law conference. Soon they become friends and involved in developing a legal chatbot. Now, 16 January, morning 6 a.m., Smita, accompanied with her friend Pooja Singh, filed a complaint under CRPC 156, Your Honor, accusing Harsh of committing sexual offences against her on 11 p.m. on 15th January. On 11 p.m. on 15th January. And Smita supported her complaint with copies of email where Harsh had expressed his emotion for her. The police sent Smita for medical examination around 7 a.m. on 16 January 2023, but the medical officer reported there was no visible marks on the Smita. The police questioned Harsh at 1 p.m. on 16 January, who while disclosing his sole relationship, denied any wrongdoing. However, the police registered a first information report on section 376 of IPC. Apprehending the arrest, Harsh has approached the session court, but his bail application was rejected.
Counsel, what is your allegation of what exactly sexual harassment was caused?
Your Honor, rape, section 376 rape, Your Honor.
Sexual harassment you have stated.
No, Your Honor. In the fact, it was clear that Smita accused Harsh of committing sexual offences. The exact offence was not mentioned in the fact, Your Honor. But the police has, after the investigation, has registered the FIR under section 376 of IPC, Your Honor. If Your Honor, is permission, much obvious, Your Honor. Apprehending the arrest, Harsh immediately moved to the sessions judge for anticipated bail, but his request was rejected. Again, he approached the High Court for anticipated bail, supported by a chatbot report, a draft judgment. But the High Court, without even referring to the report, has rejected the bail application. That's this case, Your Honor. If Your Honor are clear with the facts, the council seeks permission to move on to the issues at hand. Much obvious, Your Honor. Your Honor, currently there are 4 primary issues. Whether artificial intelligence is a person in law capable of giving
I mentioned the complaint was filed under section 156 of CRPC. Is it correct?
this one. Section 156 of
CRPC.
Yes.
Is it correct?
Your Honor, Section 156 provides power to police of cognizable offence.
Investigation. Police officer
As
has
in-
to investigate,
Investigate a cognizable offence. Your Honor.
right?
Indeed, Your Honor.
You made a mention.
Complaint filed under what provision? Criminal contempt complaint filed under what provision?
Your Honor, no.
You're not aware?
They are in cognizable offences. The police.
Complaint to police station is filed under what provision? You are an advocate, you must know basics. 154?
It is like this.
Your Honor, the fact.
If you imagine facts and make submissions, we accept that and pass a judgment that becomes obiter.
Indeed, Your Honor. But
Unimagined facts.
indeed, Your Honor.
You are not to argue on imagined facts. You have to go by the fact sheet.
Your Honor, in the fact sheet it was mentioned the complaint was filed under section 1.
156, you should have examined as a council.
What is 156?
What is
The police
Without
without.
156.
In the,
Went up.
no, Your Honor, the council has looked into the 156 where the police officer without arrest warrant or without a magistrate order.
Now read the sentence in your fact sheet. 3. Paragraph 3. Fact sheet we don't have.
Indeed, Your Honor.
Paragraph 3.
On the early morning of 16 January 2023 at 6 am, Smita, accompanied by her lawyer Pooja Singh, who was her schoolmate, filed a complaint under section 156 of Code of Criminal Procedure Code before the police, accusing her of committing.
This is all we are asking.
whether a complaint can be filed under 156? If not, then under what?
What
What
provision?
it can be filed under.
Not under 156 because we have not read it. That's the reason.
So you are not read properly 156.
Apologies, the council ignorance.
Is under 154.
Proceed.
Apologies, sir. Your Honor, the council seeks permission to modification. Much obviously, Your Honor. Whether artificial intelligence is a person in law capable of giving opinion. Whether the report of J.N.V.L chatbot constitutional opinion of expert admissible under the provisions of Evidence Act 1872. Whether the reliance on the report of chatbot by a judge amounts to abdication of judicial functions or amounting to acting contrary to the constitutional mandate of judge. Whether the High Court erred in declining to grant bail to Harsh Kulkarni. I will be dealing the first two issues and my co-counsel will be dealing the rest two issues. The council seeks permission to move on to the arguments at once.
Yes.
Much obliged, Your Honor. Your Honor, as the appellant has stated, there are two types of persons in law, Your Honor. That is the natural person and the juristic person. But to confer to be a legal personhood, the artificial juristic person should be recognized by the law, Your Honor. For that, it has to satisfy certain essential conditions, characteristics such as the right to be sued and to be sued, to hold property in its name, and other various other immunities and protections, Your Honor. Your Honor, it is to be noted that at present in India and all over the world, artificial intelligence is not conferred with legal personhood. It is only considered as a tool, Your Honor. Your Honor, let us take an example. If a company has been granted legal personhood in India, it satisfies all the essential characteristics of legal personhood. And when the company is punished, in case of a lifting of corporate bail, the stakeholders of the company will also be punished. But in the case of artificial intelligence, who will be punished is a big loophole in that case, Your Honor. Your Honor, it is submitted that AI can only be used as a tool and cannot be considered as a person as there are practical difficulties involved and a legal personality should be granted only if it is consistent with the legal system. The appellant side has also admitted that artificial intelligence is a tool, Your Honor. The cases stated by appellant side, in the first case, in Shiromani Gurudwara, they have stated that artificial person can be any entity. But they have hit the fact that the court also stated that only a juristic person is a only person if it is recognized by the law, Your Honor. Also, they have quoted the Ramesh Chandra case and Regency Hospitals case, Your Honor. In that, regarding to the expert, regarding to the expert, it was stated that an expert regarding.
Still, please make your submissions first.
Indeed.
Why you are jumping to the conclusion that the court has accepted whatever that was submitted by them?
Apologies, Your Honor. The council would like to continue. Your Honor, the chatbot AI that has generated a report only based on the input, Your Honor. For example, if there are two scenarios, Smita in her favor has given a
It is like this. These are all computers, whatever. They have evolved two stages.
Indeed, Your Honor.
Okay. First was performance level computer.
Indeed, Your Honor.
Next was predictive level computer.
Indeed, Your Honor.
Next is cognitive.
Indeed, Your Honor.
Okay. So when you go to the level of cognitive computers, that is not based on input. That is independent of it. Okay. Right now, this is switched off, but it is working.
Indeed.
And it is listening. This is not based on, it is framed to be like that. It is not just predictive.
Your Honor, the count.
It is cognitive also.
Indeed.
So depending upon what I do here, it thinks what I read. And it sends me a message about where I am.
The council would slightly like to differ from you. As the Honorable.
No, you see, if you are trying to differ, you will be differing with the technological facts. That's what a cognitive computer is. Whether you like or not, that's what it is.
The council would like to slightly differ from you. As you have stated, the cognitive as you have stated that the phone was switched off and it's working on it. Before the phone was created, it was made by a software and it's a pre-programmed program. Apart from the software or the pre-programmed program, the phone will not go beyond the scope, Your Honor.
Artificial intelligence has gone to highest level now.
Indeed, Your Honor. Indeed, Your Honor.
Now, for example, robotic surgeries.
Indeed, Your Honor.
The doctor doesn't play any role.
Indeed, Your Honor. But it's still.
It plays with the life of a person.
Indeed, Your Honor.
Then why not rely upon such opinion? That's all is our question.
Your Honor, there is no accuracy and reliability or credibility in case of the opinion, Your Honor. This can be proved by decoding the chatbot jail or death report, Your Honor. In the fact sheet, the chatbot has stated, the draft judgment, it was stated that the emails relied upon by Smita in her complaint do not convey any inappropriate on the part of Harsh, since emails and messages are typical among youngsters after returning from the pubs, Your Honor. In the fact sheet, it was clear that Harsh was a corporate lawyer and Smita was a lecturer. The chatbot itself assumed that Harsh's the emails given by Smita was between among youngsters after returning from the pub, Your Honor. The report further stated that disclosing of emotion is no evidence of offense of sexual assault. Your Honor, it is to be noted that in the fact sheet it was clear that Smita accused Harsh of committing sexual offences and the police filed FIR on 376 IPC, Your Honor. But the chatbot itself assumed that it is no evidence of sexual assault, Your Honor. Next, the point states, Smita and Harsh were apparently dating, said the report. In the fact sheet, it was clear that Smita and Harsh were just friends, Your Honor, and were involved in developing a chatbot. The report also ruled out Harsh fleeing, since being a lawyer, he is a responsible person and was cooperated in the investigation. Your Honor, being this as a cognizable offence and a heinous offence under section 376 of IPC, whether Harsh is a lawyer or not is irrelevant to the fact, Your Honor. The report took note of the fact that there are no visible marks on the body of Smita. The High Court has rejected the bail application on the prima facie of section 114A of the Evidence Act, Your Honor, but the chatbot did not took it this top one. The report concluded that whether AI is a legal person. That's what, Your Honor. AI is not a legal person, it's just a tool, Your Honor. For that, even its whether it is capable of opinion, Your Honor.
What are the criteria for granting persecution?
Your Honor. First, Your Honor, they should have certain essential characteristics. such as sue and to be sued, to hold property and perpetual succession, various other immunities, Your Honor. But they did not satisfy any of this, and the big question is, in case of disputes, let us consider if a human commits a violation, Your Honor. He is given prison term, he is given fine. What if in case of the A? We can't hold A liable, Your Honor. This will be really misused in a way and will lead to lot of repercussions, Your Honor. And this can be proved by the chatbot report, Your Honor. Even in case of hypothetical situation, if you the court would like to consider the report is only in the favor of us as per the input given by him, Your Honor. At the last point of the report noted that the report concluded that the complaint and material read together constitute a case under section 354A. That
your argument that only it is against in favor of you, it should be not accepted.
The council like to differ from the point, Your Honor. The council say the artificial intelligence is still in the development stage. It has to go to various training and various testers to become a competent chatbot. Even it is a chatbot or machine, it's still capable of committing mistake. And this is evident from the report it has generated, Your Honor. Your Honor, in the last
artificial intelligence is growing.
Indeed, Your Honor.
Intelligence also is growing.
Indeed, Your Honor.
Judges' intelligence also grows. That's why he overrules subsequent judges, come and overrule the earlier judge. This is a process. At that point of level, whether those opinions are reliable or not, whether the program is such, whether the invention is such that we can, you see, in the field of cancer treatment, artificial intelligence is yielding a success of 99.99. Okay?
Indeed, Your Honor.
Read all the reports and the line of treatment that is to be, and in Karnataka, Manipal Hospital has hired the services of this artificial intelligence. Human being cannot match that level of 99.99 accuracy in treating cancer. What is wrong in
considering at least opinion?
Your Honor, the council accepts that artificial intelligence has really various advantages. But the council contests that yes, indeed it has various potential, but it should be only treated as a tool, Your Honor. Giving personhood is against the ethical norms. The artificial intelligence.
The petitioner wants it to be used as a tool. That is opinion. They don't say that you must accept it.
In your
they don't say that it must be accepted.
In their memorial.
Please consider this. That's all opinion. Why not consider?
It cannot be considered as a credible opinion because
that we will decide whether it is credible or not. Why not accept that opinion? As an opinion, it is only an opinion.
Your Honor.
It may be accepted, rejected.
Indeed, Your Honor. As the petitioner has stated, the artificial intelligence has been trained with pre-programmed and algorithms, Your Honor, and with various judgments and books. But it is to be updated in every now and then, Your Honor. But what if in case it is not updated, it may provide.
it updates itself. Okay, once created, it updates itself. And any development all over the world, any movement round the clock, without fault, it updates.
Your Honor, with pertinent to your question, the council ourselves has used artificial intelligence to ask the artificial intelligence whether it can be considered as an expert opinion or the report. Artificial. 1 minute. Excuse me. The artificial intelligence itself is stated that it is mere tool and it cannot be imposed on the judiciary and it can only serve as a reference purpose, Your Honor. It itself accepts it as a mere tool and it itself clears that it is just a...
Again, relying upon the artificial intelligence report, that's all.
No, the
ChatGPT,
relying
upon it.
No, the council would like to differ from the point, Your Honor. The ChatGPT itself, it's a pre-programmed program. The programmer itself is designed, Your Honor. The programmer itself has stated that it is just a mere tool, Your Honor. But the councils in their memorials really has depicted it as a juridical person and has stated in that's why the council would like to submit that.
Yeah. Proceed.
Indeed, Your Honor. Your Honor, in the case of Christian Louboutin SARS versus Shoe Boutique, the High Court held that in the present stage of technology's development, AI cannot be able to replace human intelligence in the process of adjudication and stressed that the responses from chatbots cannot be used to adjudicate legal or factual matters in the court of Your Honor. And also, it is to be noted noted that the boundaries of the AI is not well defined and the content is generated through various algorithms. This leads to the breach of sensitive data and also a violation of privacy. Your Honor, in the present case, the complaint is between the Smitha and
your first issue is very simple. Whether it is a person.
It is not.
Whether it leads to violation of privacy, XYZ, information, data protection, that is a different issue. Right?
Indeed, Your Honor.
Your submission is that this is not a person.
Indeed, Your Honor.
Why it is not a person?
Your Honor, because it does not satisfy the essential characters to grant legal persons, as I was stated in the, previously, and also it did not provide any report, accurate report on credibility. That's why it cannot be considered as a person, and it reports may also based on the.
Who can decide it is accurate or not? How can you say that?
Your Honor, the council seeks pardon that the council did not state that it's I am deciding the accuracy. The council is just
Your argument is based on the
opinions and grade.
That's right. You said that it is not incorrect.
The council
Accept it.
the council argued based on the chatbot report in the present case, Your Honor. That is not accurate, Your Honor. That is what the council would like to convey to the bench, Your Honor. If Your Honor,
Based on what? According to you, why it is not accurate?
Your Honor, in the last point, it was stated that the report concluded that the complaint and material read together constitute a case under 354A, under section 376. Before 3 lines before that, it was stated that disclosing of emotion is no evidence of sexual assault. Your Honor, 354 talks about assault or outraging the modesty of women. But at concluding the report, it has stated under section 354A, which provides for sexual harassment, Your Honor, and to get a lower imprisonment, Your Honor. This clearly favors in case of us. That's why this report is not reliable, Your Honor.
Okay, proceed.
Much obvious, Your Honor. Your Honor, the appellants have mentioned that IPR
The submissions you made about accuracy of the opinions, etc.
Indeed, Your Honor.
You have not submitted in our Ramudes. This argument is not there in our submissions. Because you looked at the petitioners, you are spoiling your case.
No, Your Honor. As per their argument, the bench also questioned that whether the report is reliable. That's why the council has decoded the report, Your Honor.
We didn't ask you whether it is reliable.
Since it is pertinent to explain the veracity of the case.
When I go to a shopping mall, I should buy what I want, not what they sell. You have spoken again and you are buying that.
Indeed, Your Honor, but the respondent in the position to indeed, Your Honor, opposition.
Second issue. That's all.
Your Honor, the final case law is that in Stephen Thaler was the Comptroller General of Decide on Trademark, it was stated that there was a Darbo's artificial intelligence system and he would apply patent stating that artificial intelligence should be considered as a inventory, Your Honor. But he applied the patent application to 3 jurisdictions all over the world, and the 3 jurisdictions rejected his application stating that AI is not a legal person, Your Honor. By this, the council would like to move on to the second issue. Much obvious, Your Honor. The second issue pertains to whether report of JLR chatbot constitutes an opinion of expert admissible under the provisions of Evidence Act 1872. Your Honor, Section 45 clearly provides for who are experts and the opinion of experts, Your Honor. The section reads that when the court has to form an opinion upon a point of foreign law, of science or art, or has to identify of handwriting, the opinions upon that point of person, specially created in such foreign law, science or art, person has to identify handwriting or relevant fact, such persons are called experts, Your Honor. Here, it was clearly stated the opinion will be only provided when the court has to form an opinion, Your Honor. But in the High Court, the court did not ask for any opinion. Since he have no pertinent evidence, he has relied on the mere chatbot to generate a report and submit it to Your Honor. And it is to be noted that only such persons are called experts, Your Honor. And even in case, in a hypothetical situation, if a opinion should be considered.
Madam, those are hypothetical question we will consider later. Already we have cautioned them that we will not proceed on hypothetical facts.
Indeed.
We go by the concrete facts which are there on the table.
Indeed.
And when we go through your written submissions,
Indeed, Your Honor.
it is very peculiar that the main headings are not underlined, sub-headings are underlined,
Which page?
all pages. Issue 1, okay, issue is not underlined, sub-heading is underlined, right?
Indeed, Your Honor.
Why?
It's on issues already we have bold, we are given a bold, so.
No, why you have underlined these things? Because they are also bold, they are also in capitals.
Indeed, Your Honor, but since council would like to proceed, like it is a two-fold issue, I'll be dealing with the threefold matter, but due to the
No,
time.
not like this. Why you have underlined somewhere, not underlined somewhere? 1. And section 45 is in italics here. Why it is in italics?
Apologies, Your Honor, it's my being.
Heading is straight and the section is slant.
Apologies, Your Honor, it might be clerical error.
Hire a good clerk. Because when you have signed, this is your typing.
Indeed, Your Honor, but we have due to the paucity of time, we didn't have enough time to. In section 51, grounds of opinion when relevant, it was clear that whenever the opinion of any living person is relevant, the grounds on which such opinion is based are also relevant, Your Honor. In this ground statute, it was clearly stated that the opinion of any living person is only relevant, Your Honor, whereas the artificial intelligence is just a mere tool, Your Honor. So its opinion, it is not a legal person, it is not capable of giving opinion, and its opinion should not be relied upon. Your Honor, recently.
1 minute.
Indeed.
The experts, you are living expert, you call it living person.
Indeed, Your Honor.
Living person's opinion is dependent upon what the scientific data is given, isn't it?
Indeed, Your Honor.
Now, for example, there is a gunshot wound. How to decide this particular bullet hit? There is a ballistic expert.
Indeed, Your Honor.
He relies upon the machinery. It projects whether it can be from the same bullet or same gun, etc.
Indeed, Your Honor.
Or blood groups.
Indeed, Your Honor. Indeed, Your Honor.
Whether it is he has no knowledge. He has to depend upon the scientific experiment.
Indeed, Your Honor.
Correct.
Indeed, Your Honor.
So why not this scientific information given by artificial intelligence should not be accepted?
That is what the council would also like. He uses the artificial intelligence as a tool, Your Honor, not as a tool.
Totally his opinion is based on that. If he says the opinion, the data collected or scientific information given says that this gun could not have been fired or this injury could not have been made by this gun. Now he says, yes, this is a scientific report, I sign it. That's all.
But there is a human intervention involved in here.
No human intervention, yes, expert's opinion.
To enter the correct data into the program, there is a human intervention, Your Honor. Here, the art.
Yes.
Yeah, but it is to be noted that let us consider that the tool is used to give an opinion. But whether the tool can explain its reasons, it can be only explained by the living persons, Your Honor. When the court questions the expert has to come to the court and to explain on what reasons and what basis he has given that opinion, Your Honor. But whether to consider the opinion or not is a clear discretion of the court, Your Honor. That's why human intervention is very important, and artificial intelligence is not expert and cannot be, and its opinion cannot be admissible as expert opinion, Your Honor. Recently, it is to be noted that to become an expert, it is to be submitted that recently in New York,
Patent was granted.
no, Your Honor, the council would like to differ from the point, Your Honor. It is submitted that recently in New York, a lawyer used ChatGPT for his legal research and is now facing court hearings since several cases cited by him using ChatGPT do not exist. It was stated by the text experts that the ChatGPT hallucinates. Even there was a case where the ChatGPT itself creates fake cases and hallucinates, and demonstrated that there was a professor who committed sexual offences against the students, Your Honor. This clearly shows the loophole in the ChatGPT, Your Honor. Therefore, ChatGPT is not an expert, and its opinion should not be admissible under the Evidence Act of expert opinion, Your Honor. If Your Honor is satisfied with my submission, my co-counsel will be dealing the rest issues, Your Honor.
Yes, correct.
Much obvious, Your Honor.
You need to say that it is subject to AI can also be.
Indeed, Your Honor. The prime example is the chat report generated by jail or bail, Your itself assumes that it is a text message sent by youngsters, Your Honor, and it itself deviates from, and it's contrary to its own point, Your Honor. And the judicial authority has the authority to adjudicate the judgment, and the AI can be only used as a tool to aid for aiding purpose, Your Honor. And from this, it can only be considered as the judicial authority cannot delegate its superior powers to mere tool or AI, Your Honor. Therefore, it is not an expert, and it is opinion is not admissible in this case, Your Honor. My co-counsel will be dealing the next two issues, Your Honor.
The counsel seeks permission to approach the court.
Yes.
Much obliged to Your Worship.
This is the counsel number 2, and I will be dealing with the issue number 3 and issue number 4 on behalf of the respondent, Your Honor.
You are thinking you are dealing with issues? You are thinking of that or you are making submissions?
I'm making submissions.
Make submissions, don't think of it. I think I don't think. Chatbot things.
The counsel seeks permission to move on to the arguments. Issue number 3. Whether the reliance on the report of the chatbot by a judge amounts to the abdication of his judicial functions or amounts to acting contrary to the constitutional mandate as a judge. It is most humbly submitted before this honorable court that if the report generated by the chatbot is relied upon, it will absolutely amount to the abdication of the judicial functions and will intervene and will act contrary to the constitutional mandate as a judge, Your Lordship. Your Lordship, it is to be noted that the court below, the justice has rendered the judgment only upon thoroughly perusing the documents provided by the appellant of the case in hand and the victim of the case in hand, Your Lordship. Your Lordship, only upon the thorough evaluation of the evidence and circumstances of analyzing the circumstances of the case, the court below has righteously passed an order of rejecting the bail, anticipated bail application initiated by the appellant of the case in hand, Your Lordship. And thus, it is only the discretion of the honorable court to whether rely upon or to reject the report generated by the chatbot, Your Lordship. Your Lordship, it is to be noted that according to the constitutional doctrine of parens patriae, it is the rights and responsibilities of the state. Doctrine of parens patriae.
Where is that?
Your Lordship, constitutional doctrine.
What is the doctrine?
Parens patriae. Parens patriae. Your Lordship, it is the right.
What is that? Court wants to know what is this.
Your Lordship, it is the right and responsibility of the state to protect and safeguard the fundamental rights of every individual, Your Lordship. And thus, the rejection of the bail application and the non-reliance of the report generated by the chatbot is clearly aligned with the state of exercising its functions and roles. Absolutely, Your Lordship. And thus, it is the only upon the discretion of the honorable court to whether accept or reject the report generated by the chatbot, Your Lordship. Your Lordship, it is to be noted that the non-reliance of the chatbot report by the Honorable High Court justifies the verdict passed by it as just and fair, Your Lordship. Your Lordship, it is to be noted that under Article 14 of the Constitution, it mandates the access to justice, Your Lordship. It also states that the doctrine of due process of law protects the right of the every individual, thereby giving the justice fairly and justly, Your Lordship.
Where is this doctrine of due process? Doctrine of
Constitutional doctrines, Your Lordship.
Where is that?
Your Lordship, stating the essence of the doctrine, the counsel seeks permission to connect the issue.
You have not mentioned this due process anywhere in your submission. That word is not there.
Your Lordship, it is stated in it is a substantial argument for Article 14, Your Lordship.
In 14 there is no due process.
Your Lordship, every individual is to be protected with the rights and should be given equal protection under law, Lordship. That is what is being stated under doctrine of due process of law, Your Lordship. The justice should be rendered fairly and justly, Your Lordship. That is what is stated in the doctrine, Your Lordship. It is in consent with the Article 14 of the Constitution, Your Lordship. Thus, it is the fundamental, that it is the substantive fundamental right of a victim.
Lordship so many times, I am not going to give half of my salary.
Now, counsel, Article 14 applies to both. To a petitioner also.
Your Lordship, considering the right of the appellant and balancing the interest of the victim, the interest of the victim plays a vital role, and thus it.
Why? His liberty is involved, which is the most fundamental right.
Your Lordship, it is pertinent to note from the fact that the victim of the case in hand has underwent sexual offences. Your Lordship, it is.
This is an allegation only. This is presently it is an allegation. He is not convicted. Now he has got his own fundamental right to approach the court. What is wrong with that? Where is Article 14? You are invoking Article 14 in your favor.
Your Lordship,
Article 14 is also available to them.
Your Lordship, considering the right vested upon the appellant, the interest also should have been safeguarded. No, Your Lordship.
Yes.
Under Article 14, the interest of the victim is also to be secured. That is what.
Also to be secured. So a court is meant now to look into the interest of both.
Your Lordship,
You can't say that due process only for my purpose and it will be sufficient for me, not to consider due process for them.
Your Lordship, the counsel for the respondent humbly pleads before this honourable court that the right vested upon the appellant is not entirely denied, Your Lordship, whereas it is subjected to certain reasonable restrictions. Under Article 21, it is the right of right to life and personal liberty is vested with either parties, whereas the appellant of the case in hand has been accused to intervene and has accused to have committed sexual offences, Your Lordship. Your Lordship, when the victim has undergone the sexual offences, it is to be considered that the interest of the victim should be safeguarded, Your Lordship. Your Lordship, it is further stated that considering the right to life and personal liberty of the victim of the case in hand, she has righteously approached
At
the.
this stage, that question doesn't arise. It is not yet proved
Yeah.
that sexual harassment has been caused or he is responsible.
Your Lordship.
How this your argument?
Your Lordship, it is prima facie from the complaint instituted by the victim of the case in hand, where she has enumerated that sexual offences have been committed against her. And considering all these circumstances, it is to be noted that the court below has righteously founded its light upon section 114A of Evidence Act and has decided the matter on merits and has passed an order in favor by rejecting the anticipated bail application initiated by the appellants of the case in hand. Moreover, Your Lordship, it is to be noted that the trauma faced by the victim of the case in hand is immense as compared to the right vested upon the appellant of the case in hand, Your Lordship. By considering both the circumstances, the victim of the case in hand's right has been vehemently infringed, Your Lordship. That is what is being submitted, Your Lordship.
Vehemently or violently?
What if the judge gives reasons why he is relying on the chatbot?
Then what happens?
Your Lordship, it is.
The reliance either it may be in favor or
Against.
So if he gives reasons,
What is wrong in giving at least look into that?
and either he is rejecting or accepting, he gives reasons,
Your Lordship,
and that won't amount to abdication of his judicial.
Your Lordship, it is to be noted that the facts presented by the appellant has been suppressed. That the Chartwood report is being referred to as the draft judgment, Your Lordship. It is to be understood that the draft judgment. Indeed, yes, Your Lordship. Your Lordship, the report generated by the chart board itself is of dubious contents, Your Lordship. It has stated the erroneous provisions under which it is not properly mandated, Your Lordship, and thus it is evident from the report generated by the chart board that it is fabricated, Your Lordship. It has only been stated only upon the inputs inserted by the appellants of the case in hand, Your Lordship. Your Lordship, it is to be noted noted that in the case of S.N.V.L versus the state of Karnataka, it has been clearly stated that the technology must only be used as a tool, whereas it cannot intervene into the justice delivery mechanism, your lordship. And thus, it is the discretion of this honorable court to whether admit the it is the discretion of this honorable court to whether admit the report generated by the chatbot or to reject the report generated by the chatbot, your lordship. But it is highlighted that the report generated by the chatbot is absolutely erroneous, your lordship. Your lordship, it has been clearly verified by the court below, and it has been righteously pronounced that the non-reliance of chatbot report will amount to the application of the judicial functions of the judge, your lordship. If your if your lordship are convinced with arguments advanced, the council seeks permission to move on to the issue number 4. Much obliged, your lordship. Whether the High Court has erred in declining to grant bail to Harsh Kulkarni. It is most humbly submitted before this honorable court that the stringent denial of anticipatory bail underscores the court's commitment of legal integrity and adherence to the rule of law, your lordship. Your lordship, it is to be seen that under section 438 of Criminal Procedure Code, it has been stated that the gravity of the offence should be looked into, and only upon that the anticipatory bail can be granted or rejected, your lordship. It is clear from the fact that the appellant of the case in hand has committed a sexual offence, and which is what is booked under section 376 by the police authorities, and it is evident that from the prima facie from the complaint instituted by the victim of the case in hand, the court below has righteously passed an order that the appellant is denied with the bail, your lordship. Your lordship.
What is the criteria for granting bail as laid down by Justice Krishna here? Long back. What is the criteria? Jail or bail? What are the criteria given there? We are not aware. That's the most important judgment. Jail or bail? Jail is an exception.
Exception and bail is the
Then why not?
Your lordship, the gravity of the offence that has been committed to the victim of the case in hand is immense, your lordship. Only upon considering all those evidences and perusing the documents provided by the victim of the case in hand, the court below has righteously rejected the anticipatory bail application instituted by the appellants of the case in hand, your lordship. Your lordship, it is to be noted that the appellant of the case in hand has committed the offence of sexual offences, which is punishable under section 376, your lordship, and thus it is the respondent counsel pleads before this honourable court that the appellant, the appeal initiated by the appellant is liable to be set aside as inhuman, your lordship.
For your submissions on issue 4, you are not relying upon any judgment of any court. Okay, all the points that you have raised have no relevance to this case.
Now, ultimately, what is the criteria for granting anticipatory bail?
That's it.
What are the
That's it.
points required decided by this court?
Your lordship, it is clearly stated in section 438 of criminal procedure, where it has enumerated that the granting of anticipatory bail must look into the gravity of the offence and whether the accused will flee if the bail is granted, or if the accused will tamper with the evidence or commit further.
It's a heinous crime.
Indeed, yes, your
Why
lordship.
not? He is a practicing advocate.
Your lordship.
Where is the question of fleeing from away from? His livelihood will go.
Your lordship, since he has committed a cognizable offence, your lordship, if the anticipatory bail is committed,
We accept for a moment that he has committed heinous crime. Fine. But there is 3 points are there, isn't it?
Indeed, yes, your lordship.
One is nature of the crime. Second is chances of his running away or fleeing from the justice. And no criminal anticipation. Two are we accept, all right. But what about the chances of escaping? What is the reason? Why should not consider? He's a practicing advocate.
Your Lordship, it is the only ground that satisfies the accused, Your Lordship. It is to be noted that the accused of the case in hand, if at all he is left out by granting anticipatory bail, has a very good chances of tampering the evidence or deterring this honorable.
You read the paragraph.
What is, madam, 1 minute. What is tampering of evidence you are going to? You are the complainant. He has to influence you to say that nothing is wrong. That's all. What else he can do? Tampering. What is the tampering here?
Your Lordship.
Already there is a medical report.
Your Lordship, it is to be noted that the appellant of the case in hand is supporting their arguments with the chatbot report generated.
That doesn't amount to tampering of evidence. That doesn't amount to tampering of evidence.
You are answering the question on what are the parameters for granting and anticipatory bail. You reject that.
The counsel seeks apologies, Your Lordship. Your Lordship, if at all the accused is, if at all the appellant is left on anticipatory bail, if at all the appellant is granted anticipatory bail, there are vehement chances that the appellant of the case in hand will threaten the victim of the case in hand, Your Lordship, and thus it will amount to further infringement of the victim's substantive fundamental rights, Your Lordship.
That can be taken care of by imposing stringent conditions. Right? Now, kindly come to the para 4 of the Moot proposal. Read that. Para 4, which they have not appreciated those facts. Para 4, please read.
Smita supported her complaint with copies of email where Harsh has expressed his emotion for her. The police sent Smita for medical examination around 7 a.m. on 16th January 2023, but the medical officer reported no visible marks on her body. The police questioned Harsh at 1 p.m. on 16th January 2023, who while disclosing his sordid relationship denied any wrongdoing. However, police registered first information report against Harsh for offence punishable under section 376 of IPC on 16th January 2023.
Whether due procedure prescribed in the CRPC is followed here. See the sequence of events, right? She approached the police, filed a complaint. What they did, immediately they took her to medical examination. Then what happened? They got the report. Thereafter, they summoned the accused. Then he was inquired. Thereafter, FIR is registered. Thereafter, FIR is registered. And what the police officer is supposed to do when the cognizable offence is reported?
Your Lordship,
he has to register FIR as per the Lalita Kumari judgment, 5 justices bench judgment of this court, where it is incumbent upon the police officer to register FIR as soon as he receives information relating to cognizable offences. Here, morning she came, she filed a complaint, FIR was not registered. She was taken to the medical examination without FIR. So, why the accused petitioner, he entitled to anticipate bail because of this
investigation is defective.
Your Lordship, under section 156 of the Criminal Procedure Code, which enumerates the police officer's power to investigate a cognizable offence, it has stated clearly in the
this precisely is the issue. Lalita Kumari judgment. It is the duty of the police officer to register FIR, then proceed with the investigation when the cognizable offence is reported to him. In case of non-cognizable offences, then he has got the preliminary inquiry has to be conducted. Matrimonial offences, say for example, whether there is a dowry harassment, etc., commercial disputes. The court has listed out some instances where preliminary inquiry is necessary. But in a case of this nature, where sexual offence is alleged, it is incumbent upon the police officer to register a FIR and then proceed, so as to avoid any thing. Right? He has to send it to the court immediately as soon as he registers the FIR.
Your Lordship, it is pertinent to note that in the fact sheet, it has been stated that the complaint instituted by the victim of the case in hand is mere sexual offences, Your Lordship. In order to ascertain how she was offended by the accused of the case in hand.
What exactly is the nature of sexual offence you mean? sexual harassment, what exactly he wanted to ascertain, isn't it? Whether it is rape or it is molestation or whatever it is, he wanted to verify, and hence he sent to the medical officer. That's what you mean to say.
Your Lordship, the facts aside from me. Your Lordship,
Conclude.
Before that, I am not understanding what you have written in para 52. Can you read it out for me?
Yes, Your Lordship. Your Lordship, thus the High Court's denial of bail to Harsh Kulkarni adeptly navigates the delicate balance between the individual rights and societal welfare, embodying a commitment to justice, Your Lordship. The decision rooted in establishment of legal principles, reflecting conscientious effort to harmonize constitutional ideals. The stringent denial of anticipatory bail in adherence to the rule of law underscores the court's dedication to legal integrity. The commitment to ensuring a fair trial, even at the expense of stringent measures, affirming this decision is a testament to court's role in fostering a society where justice prevails and individual rights coexist with the collective welfare. Your Lordship, it is.
This should have been your main argument.
Your Lordship,
So you have put it beautifully, but this is not what we are arguing.
Your Lordship, it is the duty of the state to ensure the.
All right, you conclude.
It is the duty of the state to maintain the law and order, Lordship, and that is why the responding counsel pleads before this honourable court to reject the application initiated by the appellant of the case in hand of denial of anticipatory bail, and that will amount to the interest of the people at large, and that will be justifiable for the victim of the case in hand, and therefore the responding counsel pleads before the honourable court to uphold the judgment pronounced by the court below as just and fair, Your Lordship. If Your Lordship are convinced, the counsel seeks permission to move on to the prayer.
Okay.
Much obliged, Your Lordship. In the light of the issues raised, arguments advanced, and authorities cited, may this honourable court be pleased to declare the chatbot bail or jail is not a person in the eyes of law, declare the chatbot bail or jail is not an expert, and
Prayer should be only one line.
Indeed, Your Lordship. Therefore, in the lights of the issues raised, arguments advanced, and authorities cited, may this honourable court be pleased to deny the anticipatory bail application and pass further or other orders.
Reject the petition.
Reject the petition. And thus render justice, Your Lordship.
Okay.
The counsel seeks permission to rest the case.
Yes.
Much obliged, Your Lordship.
Any rebuttal?
Yes, madam.
Yes, okay.
My lords.
Yes.
My lords, the first rebuttal is with regards to page number 11 of the respondent's memorial, my lords, wherein in para number 3 they have referred to the case of Somprakash Reiki versus Union of India, my lords, which particularly spoke about whether Bharat Petroleum Corporation, which was registered under the Companies Act, is whether it comes or not under the definition of state under Article 12. However, my lords, the counsels for the respondents have stated that in Somprakash Reiki versus Union of India, this Honourable High Court held that AI cannot be considered as a juristic person. This is the case from 1981, my lords, where AI didn't even exist, and that leads to a falsification of a case and a falsification of a submission made before this bench, my lords.
Which paragraph?
My lords, para number 3, my lords, of page number 11 of the respondent's memorandum.
What are the opening words of Article 12?
My lords, whether there exists
Opening words, you know, the text of the Constitution?
no, my lords.
Then why you have come to the Supreme Court without a copy of the Constitution? And this is the Constitution day to day.
My lords, the council seeks apologies for the same.
Unless the
You-
context, otherwise.
Request, yes.
You want to report that para? Without knowing what is the text of the article on the basis of which the judgment is delivered?
My lords, the counsels for the petitioners would like to seek clarification on the basis that the facts do not go hand in hand at all with respect to AI, my lords, and this case was back in 1981.
How you have arrived at that conclusion that the case is irrelevant? Because you do not know what is the article on the basis of which the judgment is delivered.
My lords, back then in 1981 there was no existence, my lords, of artificial intelligence, and they have gone to the extent to held that in this case.
When the Constitution was adopted, artificial intelligence was not there.
Please, my lords.
Okay, privacy was not there.
Please, my lords.
That is the dynamic Constitution. It adopts its provides answers.
Please, my lords.
Next.
My lords, the second rebuttal is with regards to page 15, my lords, wherein they have stated about the. Please, my lords. My lords, the second rebuttal is with regards to page number 15, my lords, 17th paragraph, wherein they have spoken about the case of New York.
So you can't rely upon their pleadings.
No, my lords.
The case must be strong. They may be
No, my lords.
not depending upon their argument.
Please, my lords. The only question.
What is your rebuttal?
The only question that the counsels for the petitioners have, the counsels for the petitioners wants to know the case of the name, my lords, because they have put the footnote as India's Today, which is a website, my lords.
What
So
difference it is going to make? It doesn't make difference.
Because, my lords, there may exist an apprehension that this case does not exist at all, and it's based on a news website report, my lords. So we want clarification of the same. Much obliged, my lords.
We need not clarify anything to you.
No, my lords. We would want the clarification.
Why should we ask clarification from them?
Please, my lords.
We may accept, we may reject, that's all.
Please, my lords.
That cannot be a rebuttal. Rebuttal should be on the point you have argued and they have contradicted or something.
Please, my lords.
That's all.
My lords, they argued upon these two case laws, my lords, which is why the counsel referred. Please, my lords.
The council would like to approach.
Same method or something different?
Anything different you want to say?
Your
Or
Honor.
whether you are relying upon this judgment is right.
No, yeah.
Yes, yeah. Wait.
Your Honor, as it was well established by them, the AI's tool, Your Honor. They themselves
No,
as
his objection is 1981 judgment you have cited and you have quoted that High Court has rejected. It is wrong.
Your Honor, kindly refer the completing first page, Your Honor. Actually, the council has taken this case
Go
from.
to paragraph 14, what you have stated. You have given wrong statement, that's all is complaint.
The completing page number.
Page number 11, paragraph 3.
One.
You have stated wrong fact, wrong decision. Decision not given by the court.
Completing, Your Honor.
Forget about completing.
The decision screenshot.
This one?
Yeah, indeed, Your Honor. The first page.
Your Honor, actually it was taken from an article researched by the advocates, Your Honor, where the screenshot has been where they have analyzed this case in the point view of IPR, the first page, Your Honor. The screenshot. Where we have analyzed this case in the view of IPR, Your Honor. That view only was stated in my arguments, Your Honor. That's. And inverting into the next question, please.
1 minute.
Indeed.
Go to the Som Prakash, please, point is 1981.
Your Honor, they.
1 minute. He is explaining something. Have patience.
1981.
There may be a click. There may be a click.
Counsel, have patience. Listen first. What are our questions? What we are saying. Then you answer.
He pointed out that at para 3 of first issue, he referred to Som Prakash Reddy versus Union of India, and the citation given is 1981 SEC 449, and you stated so saying that AI cannot be considered as juristic person. Honorable court held in that case.
Your Honor, there has been a clerical error. The court's view within consonant. That was the screenshot, Your Honor. That may be that is a clerical error. That is not held but the view was used in the IPR, which was clear from the article's screenshot which I had submitted in the
Whether this question fell for consideration?
No, Your Honor. But from the scholarly article, they have record.
So you have quoted wrong judgment or wrong citation. That's all is the argument. That's all. Thank you.
Your Honor, pertaining to the second question they have raised regarding page number 15, where they have if it permit, can launch it.
What is that?
That I couldn't hear it. If it pertinent, can they repeat the question?
You want to answer a question which you do not know?
We understand, Your Honor, but it was not clear, Your Honor. They have just stated a half.
Forget it. We have heard.
Anyway, you do not know the question.
All right. And then result.
Thank you, my lord.
I request the participants to exit floor for lunch and volunteers. Cafeteria 6th floor. Do we have Akshara, Sonu and Nisha here in the auditorium? Sonu and Akshara? You have arranged these. Can you just clean all these things? Take 2-3 students. Rajshekar, first year student, come. 4 volunteers, please come here. Take volunteers first. Rajshekar, I want 4 volunteers first. Write their name and first. Sir, send the 4 volunteers here. Sir, those who are coming on stage, write their name first. Wait. Rajshekar, move. I want to talk to sir. Keshav sir.
Please note the attendance
Keshav
will be
sir.
given only for people
Only
from
for
this
those are on the stage.
Second session.
Those are on the stage, take their names. Quick, come here, I am asking 2 students. Quick, come first.
Saradan.
1 minute.
Wow.
You can't
Ma'am
hear.
Morning ಕೊಟ್ಟಿಲ್ವಾ?
Stop that attendance.
Morning ಗೊತ್ತಿಲ್ಲ
I am
ಇವಾಗ
asking
ತಗೊಂತಿದ್ದಾರೆ
students to come on stage. I'll mark you absent.
I am not taking. Finally, yes, I am not taking it from any one of you attendance till the function gets over. Both 5 years as
Okay,
well as
sorry,
6 years. I want each and every year the auditorium. Whoever is there.
Sir, kindly give that attendance.
Yesterday itself, sir, kindly
You don't want to
take the attendance right now.
Please,
We want
quick.
after that
Arrange that,
Drop a message to those who are side.
We need a 6 years old. Because 6 are there.
Take out this table. Take out this. ಮ್ಯಾಮ್ ಇದು ನಾವು ಚೇರ್ ಮೇಲೆ ಇಡ್ಬೋದಾ ಟೇಬಲ್ ಮೇಲೆ ಇಡಕ್ಕ
ಟೇಬಲ್ ಮೇಲೆ ಇಡಕ್ಕಾಗಲ್ಲ ಚೇರ್ ಆ ಬ್ಲೂ ಕಲರ್ ಚೇರ್ ಮೇಲೆ ಇಡಿ ಇಲ್ಲಾಂದ್ರೆ ಈ ಚೇರ್ ಮೇಲೆ ಇಡಿ
ಈ ಚೇರ್ ಮೇಲೆ ಇಟ್ಟು ಅದೇ ಫಸ್ಟ್ ಸರಿ ಮಾಡಿ
ಅದೆಲ್ಲ ಆ ಕಡೆ ಸೈಡ್ ಇದಪ್ಪ, ಆ ಕಡೆ ಇದು ಹೋಗ್ಬೇಕಂತ.
ಆಮೇಲೆ ನಿಲ್ತಾ ಇಲ್ಲ ಟ್ರಿಪಲ್. ಹ್ಯಾಂಡ್ ಹಾಕಿದ್ದಾರೆ, ಅಗಲ ಇದೆ, ಅಗಲ ಇದೆ. ಹಲೋ